So there's a fight. There's a fight going on. We have a fight on our hands, and there is no more appropriate place to be discussing the dynamics of that fight than the First Amendment Center. Our panelists are Gene Policinski, the Senior Vice President and Executive Director of the First Amendment Center. As you know, he's been a journalist for 40 years, founding editor of USA Today. He's worked across all platforms. He's also a trustee of the National Academy of Television Arts and Sciences, as well as a professor. Christine Walls is an associate in Holland and Knight's Washington office. She's a member of their litigation section, and she worked directly on a case that we're going to discuss this morning that has secrecy and First Amendment implications embedded in every word. And finally, Jack Gillum is an investigative reporter at the Associated Press, where he focuses on money and politics, especially ahead of the presidential election. Who would have guessed? And he's a former database editor at USA Today. I'm delighted to have, and he has been at the Arizona Daily Star in Tucson. I'm going to ask each of our panelists, starting with Gene, to start us off briefly, give us sort of a big picture, 5 minutes or so. Sure. This is really intended as a discussion, and the panelists know that, so we really rely on you to help make it happen. Thanks, Gene.
Thanks a lot. Well, I think you used the word fight, and I think sometimes that's overused, but I think in the area of freedom of information, it's absolutely right, and there are a couple of reasons for that. One is the ongoing inherent tendency of any governmental unit to not want to talk about anything other than raving success, and to be irritated by people who come in and ask for information about what they're doing. To some degree, we see it everywhere. It's certainly there in government. The difference, of course, is we own what they do. The public is the boss. The public has a right to their information. What's happening today, and it's interesting, I think, with the makeup of the panel as well, is that we've moved to some degree beyond those what we would now call warm and fuzzy years of telling the public that there was a right to information and that sunshine laws should apply. So we've gotten a lot of places, legislation that says we have a right to these records, it names the records, it provides for some exclusions, and therein is the first source of controversy in what I would call sort of FOI 2.0 or 3.0 perhaps. We now have increasing requests or demands or legislation for exemptions from freedom of information laws. We have an interesting database issue, which is that more information than ever is available on these little glowing things and other places. And we have probably, I think, at least on the federal level, if not the state level, a growing tendency for public relations side, for public officials to hide the experts, to tamp down what the experts are able to say, to restrict access to them. So we have mounds of data, which we can look at very easily online. And we have no expert or very limited access to experts to tell us what it means. And the fear is that they'll get off message, they'll either be factual horrors, or they will say something that isn't in line with the current political initiative of the administration that's in power. And again, I think that's local, state, county, federal. It seems to be a growing tendency. So just as an opening thought, think about FOI now and our topics as really moving beyond this initial request where the public was all behind us because it was very easy to say, they're hiding it, we want it. Now it's this relatively more, well, you get the data. Well, but they're not available. Or, we'll be there, but we'll have a public relations person monitor the interview. And you're going to get only the spin on the data that certain people in power want to have. So we're moving beyond into this new generation of FOI fights, and we're seeing that at all levels.
Thank you. Christine?
Hi, my name is Christine Walls.
You're on. Yeah.
Okay. I'm Christine Walls. I'm an associate in the Holland and Knight. I work on a media team. We are in the process of litigating a case on behalf of the Memphis Commercial Appeal and its reporter, Mark Peruschia, against the FBI. It involves a confidential informant who provided information to the FBI on the civil rights movement and its leaders while they were in Memphis. His name was Ernest Withers, and he was a noted photographer. The photograph that he's probably most known for is the I Am a Man photograph taken during the Memphis sanitation workers strike. My client, Mark Peruschia, was reporting on this story. He submitted a FOIA request back in 2008 to the FBI seeking information on Ernest Withers and his status as a confidential informant based on a rumor in Memphis that Withers had been providing information to the FBI. The FBI delayed their response considerably, but eventually provided information that largely looked like it was inconsequential or irrelevant. But in fact, they released a document that said Ernest Withers, formerly designated as ME338R, then there was a redaction, and then it said :CI. And from this information, Mark Pruski was able to run that number, which essentially became like a Rosetta Stone, through documents that had been released in congressional investigations or publicly through other FOIA requests. He was able to run that number and put together an article that was published in 2010. But in publishing that article, the FBI was still denying that that Withers was a confidential informant. And so our client, and they also said that they had released all responsive records. Our client was concerned about this for two reasons, or they had two goals going into the litigation. The first was to get the FBI to...
I'm always the one who does that, by the way. Sorry.
The first was to get the FBI to stop denying that he was a confidential informant. And the second was to hopefully get access to the confidential informant file. I passed around copies of the case where we were able to meet the first of those goals, which was to get the FBI to stop saying that he wasn't a confidential informant. The court has now found that the FBI had officially confirmed that he was in fact a confidential informant, and now we're in the process of litigating the second issue, which is whether they can continue to withhold records about the surveillance of the civil rights movement. And the status of the litigation right now is, a couple weeks ago, Judge Jackson in DC brought the parties in and said, "Are we really litigating this issue?" And she said, "Are you really prepared? In order to withhold documents, they have to say that the documents created were, or the documents withheld were created for a law enforcement purpose." And so they've submitted a secret declaration, so I don't know exactly what it says. It's highly redacted, the version that I have. The rest of it went to the court, and that might be something we want to talk about, the use of these secret declarations in general. But after reading it, the judge called the parties in and said she was deeply disturbed by what she had read and questioned whether this administration, this attorney general, this FBI in this day and age was really committed to litigating what needed to be, the issue that needed to be litigated in order for them to continue withholding the documents, which was the surveillance of the civil rights movement, a law enforcement purpose. And she asked the parties to seriously consider going into mediation, and so we're about to enter into settlement discussions over the issues, which is highly unusual in a FOIA matter. But we do have a judge who's listening and saying, "Really?"
Let's leave it there, Jack.
Right. As a side note, I'm probably the clumsiest person in America. I'm either going to spill coffee on myself or drop something on somebody.
I'll be changing my seat.
That's right.
Can you bring the tarp in, please?
That's right. We'll have one for everyone. I agree it's a fight. I would say, I would go farther than that to say that reporters are under siege by this. I have been a practicing journalist now for about 7 years, and in that short amount of time, the idea of FOIA has seemed to rapidly decline in terms of open information and access. Even states where I first started with Terry at the Arizona Daily Star, which has, even now through other litigation, a great state public records law that allows for metadata, and the metadata is that underlying subdata in a document, like who created it, when it was accessed. The state Supreme Court said, yes, you have a right to this just like you have a right to any other data. That notwithstanding, I don't know how many times I have asked for FOIA requests. I asked for one from a state agency, a child protective services agency in a state, and the public relations officer was on all the calls. And at one point I'm like, with all due respect, you have no business being on this call. I mean, this is not your purview. I will come to you at the 11th hour when it's time for a comment for the story. You know, again, with all the respect to what you do, this is not your purview. And she, you know, and it's shocking that she was the one during the whole time who tried to keep shutting this down. Well, Jack, are those really the records? Why do you? That's the best thing. Why do you want these records? Because it's like your mother. Because I said so. Because I want the records. Period. I paid for them. I pay my taxes. I'm an upstanding citizen. I paid for my records. I think the biggest things that I can talk about, it's sort of a twofold path here. One thing is in asking for records, particularly electronic data. I've tried to make this my hobby horse. I'm a computer nerd. I came at journalism. I actually hate writing to this day. I started college as a physics major and computer science geek. I got into journalism because I thought it'd be fun to stick it to the man and hold people accountable. I love this job. I love what I do. And to be fair and to hold people accountable. And this access to data is becoming very critically difficult and critically important for us. And I think between FOIA officers and record keepers, really FOIA officers who have no understanding of data, and because they're stuck in a FOIA world, I think, where they're used to, you know, taking a piece of paper and redacting it with a black marker, and in the case of the federal government writing B6 exemption or whatever. I think when it comes to data, they get scared. They think we're going to give away, you said, the Rosetta Stone. That's one issue. The other one is for the data that we do have, the administration likes to say, we're the most transparent administration in history, and this is the comment that the White House, one of the White House spokespeople always says when we go to them and I say, okay, that's interesting, you gave us 1 million records of your visitors' logs, but you have high-powered donors and lobbyists visiting, it says the Oval Office, POTUS, 2, you know, September 3rd. Well, we're the most transparent administration in history, Jack. I'm like, well, that's completely irrelevant. But even still, the data that they give out, and I'm going to talk briefly about campaign finance, is opaque at best. It's not very timely. It's not very clear and accurate. It seems to go against the whole idea of disclosure that even in the infamous Citizens United case, the majority of the court said that, yes, unlimited money, but disclosure is the name of the game. So I can talk about those two things, but primarily, at least from the campaign finance world, which I will say a few times, I have handouts and so does she. Are they at the back?
They're in the back over there against the wall.
So I'd love to answer questions about data when we get to a data and public records request, as well as just general campaign finance. I tried to make it a grab bag for those couple things. So.
Let me ask first if any of the panelists have any questions of each other based on what you've heard, and then we're going to open it up to you. Gene?
Well, just exploring a little bit more, if I may, with both. In terms of asking for your information, I take it from the FBI, the first response was simply, no, we're not going to give any data out.
What's actually interesting is that they were relying on an exclusion that says that they can say that they've released documents to you, they've released all responsive information, even though that's not true. And let me read you the text of the exclusion because it might make it clear. It's a little Orwellian. Whenever informant records maintained by a criminal law enforcement agency are requested by a third party, the agency may treat the records as not subject to the requirements of FOIA unless the informant's status has been officially confirmed. And so if you're requesting documents, they can just say, yes, we've given you everything.
Interesting, non-denial, denial, I guess, to use an old phrase. And if I may, when you're talking about, for example, the POTUS, the President of the United States visitor log, you're getting a number of visitors.
Yes.
You're not getting the names of the visitors.
No, we do. That's the interesting thing. We do get the names, but we don't get the birth dates, which I'm sure there are reasonable privacy exclusions in there. But you know, let's say we have a big high-powered donor who's given $500,000 to a super PAC, or maybe $10 million. That's not unreasonable. In fact, that's common. And it was this person had a lot of federal contracts, you know, and his name happens to be John Smith.
Yeah.
Well, how do we know that's the same John Smith? And I mean, we would be reckless if we said that that was the same John Smith. So it's almost like you're sort of damned if you have a very unusual name in this business, because we can, but even then you don't know, you can't assume that that's not the only person. It will say whom that other person was with, or not whom, but how many people, the meeting they were in. I was looking for Lincoln bedroom furiously in those documents, but I doubt that they would let that one go. But.
Well, it is a reason I was asking about that is it raises the second big challenge, I guess, and that is increasing the use of privacy to combat freedom of information in a broader sense. Legislation to hide the names of people who are registered gun owners, legislation to hide the names of anybody, well, to take all driver's license information away. It makes it very difficult, I think, on a practical level. We've never really sort of thought about those as FOI in a way because they were just available public data. But aggregation of data is also being used as a weapon because, you know, today, what would have taken, when I started, if you wanted to find out who bought a house, you had to go down to the county clerk and they opened it up and, you know, it took a long time and you could find a record. Well, now you can aggregate the names of everybody who bought a house in Davidson County, where we are, in a matter of seconds, and you can link that to other data. And opponents are beginning to use privacy combined with aggregation as a weapon against FOI, saying essentially, you know, you can find out everything you want with one bit of information, the number from the FBI, the social security number or birth date provided on a guest list. And ironically, again, in an era in which we should be more transparent than ever, and there are very legitimate reasons to still know, that very transparency is being used as a weapon to hold back freedom of information. And it's an incredibly, I think, you know, attractive argument to the public. These people will know everything about you if we just release the one record, gun owner registrations, for example, or concealed carry permits, actually. And it's producing results, taking the high ground away from the FOI community.
Well, if I may say, I mean, is anybody here from Texas? A friend of mine, Ryan McNeil at the Dallas Morning News, he's now at Reuters, was just in this very fight with, in terms of, you know, public employees and releasing birth dates. And the state legislature tried to take it up and say, well, no, you know, we need to protect this because, you know, those people want your information. And he famously, I think it was he or it was Jen LaFleur, now Republican, one of the two, I get this confused, was at a committee hearing and said, you know, Mr. Chairman, you know, your name matches the names of 4 other people identically who have felony convictions, including one as a sex offender. So are you sure you want to have that information out there with no birth date and people just assume? And he actually said, I believe, if I'm going to, oh, we need to look at this further then. You know, so I think it's that fear, but there are ways around it. And the birth date issue, I mean, if anybody uses LexisNexis regularly, they give you the month and the year or something, just so you can give a ballpark. Again, I don't know, without thinking it through, if that's the best way to go, but at least there are reasonable sort of compromises here and against very real challenges. But I think I agree, the sort of wholesale redaction privacy, they want your data. I don't know if that works.
Christine, any comments?
No, I just agree. I was curious as to what would be enough information, just in terms of the alternate proposal, and I think the month and date makes a lot of sense.
Good. Okay. Questions? Yes.
Jane, could you guys give us a few more examples of the aggregation of data being used as a weapon?
Well, you know, it's almost the fear, again, it's the fear of aggregation in a way. Your medical records. You know, when we aggregate public health records or we aggregate information from pharmacies, which is becoming useful in finding spots or hot spots where I guess the materials, the pharmaceutical materials for meth production, for example. You know, you suddenly find a small pharmacy that's selling, you know, 12 million cases of cold medicine. I mean, you know, there's a reason people aren't just that sick in that neighborhood. But even that kind of aggregation now is being resisted either by the industry, which doesn't want to disclose that maybe there's different kinds of practices or for trade purposes or whatever. And then you find on just simple fear of this unknown of being somehow exposed in public. So you're finding moves to even hide things like home mortgage information, I mean, home sale information. A lot of the information kept on record in small, not necessarily federal agencies, but local agencies. You know, building permits. I mean, all these things that traditionally have simply been open, but you know, practically they have not been accessible. You know, you have a doctrine called practical obscurity, which is that, yeah, it was public, but who went to look? And if they did, they had to go through those 800-year-old books down in a dusty place where you caught a cold going. You know, nobody wanted to go down there and look at that stuff. So you really were obscure. Well, today we're not. And what's interesting to me is that, you know, the first battle for FOI 25, 30 years ago was just to say we really have the right to look at that. It's not the province of the county clerk. And what's happening now is, even at a very local level, it's unreasoning perhaps that we have that fear, but it's being used to say, well, no, you know, why do you want to know? First of all, you have to justify it, which is annoying. And secondly, really to shut down access for fear of some kind of disclosure of everything. You know, you'll be robbed if they find out you bought a house this big. I mean, literally, it comes down to those kinds of very wrong, and those resonate, unfortunately, with citizens who aren't, you know, going to just jump on the bandwagon for larger sort of civic reasons. One of the most, in this room, actually next door in the lecture hall, we had a session on the concealed carry permit fight in Tennessee. Memphis printed names of people in Shelby County. Again, we find a typical thing. There are felons who have these people. There are people who, you know, are definably mentally ill by the standard of dangerous to themselves and others, who are packing 357s with permits because there was no record check done. Huge public outcry. And there was a very nice man who said, I have a lot of guns. My wife is handicapped and cannot move. And if you publish my name, or someone can go and find out that I have guns in my house, someone will come to rob me and she can't defend herself. I mean, you know, and I don't know what to say to that person, except that that's his fear, and it's very hard to argue with on a human level. So I think that's what we're finding. The fight isn't so much anymore, should you or shouldn't you have access? It's really this very different argument. But I think if you looked in your locales, you'll find that there are a lot of people who don't think you should be able to look at almost any public record.
Yeah, well, we had that situation with home sales data where women will say, I'm a single person, I'm afraid now because of information about where I live, and I have an ex-husband who is trying to find me. So do you have advice for editors on what to say to those folks who actually have a case?
I mean, maybe this one, I mean, my first reaction to this, I mean, as not being an editor, is I would say, well, if your ex-husband wants to find you, he can spend 5 seconds on Google, and I guarantee that some information is going to come up. Again, that probably won't placate the reader, but at some point, and again, this is probably a very terrible answer, so I apologize, at some point you have to sort of appeal to their sense of that this is an open, free society, that we have laws established that clearly allow access to these records, and that if we start cutting off access to this, who knows what is going to be next? I mean, a confidential informant. I mean, this is, in my opinion, outrageous. That, I mean, that basically the government can just say, you're right, it's very Orwellian. Well, they don't even have to deny that those records are there. We can just say, we've given you everything based on this exemption. And maybe that's the answer. I don't know. People in this room are far wiser than I. That's my first blush response.
Well, then let's pick that up, since we have far wiser people here. What would you do or tell editors? 1, 2. Please, in front. You. Yeah.
Actually, I just had a question which goes to yours. I mean, how does this fear of disclosure of these kinds of records square with, and this would go to that woman in particular, their use of Facebook and all the rest of that stuff, aggregation of all that, the very frequent disclosure of all kinds of things you can find out about people and how they keep it.
You know, it's the same dichotomy we see on First Amendment issues across the board. You know, free speech for me, but not for the Nat Hentoff's book. You know, it's I'm worried about you. I know I'm okay. I won't misuse the information, but you know, you might. But I think on a practical level, it's actually using data more to show everything from health trends to where mortgages are being made or not. You know, I think if one of the issues that we face now is if they're using pragmatic reasons not to disclose, we need more than theory to argue against that. So I think it's the database projects that we can do where we can say, well, yeah, but you know, look, we just found out that where they've been spraying in the city for 5 years is not where the West Nile cases are turning up in our locale, because they're spraying the high-income neighborhood areas and they're not getting, you know, I mean, whatever the statistics show. But, you know, when we do these as onesie, twosies a year, you know, it's hard to point to those. I think if we can produce this kind of data on a regular basis, make it part of our regular news reports, then we have a much better argument to say, but see, this is why they should be open. And, you know, again, public health, public safety, discriminatory practices are 3 areas. If I could, you know, nobody has money to create beats anymore. We don't have beats like it. But if we did, I mean, that would be the reporter that I would want to hire first, because it's local. It tells our readers, our users about our community, and it takes this huge trove of data and gives us a reason to say this is why it's valuable to keep out, because you know, just the sort of rhetoric anymore that we got FOI with in the beginning. We deserve to know. It's the public's right to, all of a sudden Facebook and everybody's scaring people. And then they have these pragmatic reasons not to, and we are out there with theory, and they're giving hard examples, and people go, they identify with those hard examples. So I think more use of those projects is the best defense.
If I can just say one thing on that point, I think that's absolutely right. And I would say, no matter what you do, FOIA the hell out of these people.
Yeah.
And I say that because the more you get them into and I've learned this from experience, the more you get them into the practical matter that, here comes Gillum again with the FOIA. I mean, I literally have an Outlook reminder I call it FOIA Friday because I'm nerdy. I think it's funny, but in no way is it funny. Like, FOIA Friday, fun. And it is, and I FOIA agencies. I mean, I usually keep it on my beat. Sometimes I'll ask for, when those UDID iPhone serial numbers were allegedly leaked and the FBI had them, I filed a FOIA with expedited processing request asking the FBI for all emails back and forth between those two special agents about it. Because I have a right to the information, and I know David Hardy at the FOIA officer is probably like, oh, here it comes again. I would say the frequently FOIAing, because it really costs nothing. It's a letterhead, it's an email at times, and part of a beat that your reporter covers, they should be doing that regularly anyways. The second thing I would say is access to data, and that the biggest challenge that I would say that reporters have is asking for data in the right way. When I was at USA Today, we asked a state education department for records, which turned out to be maybe a couple million records, which, people don't work with data, but with maybe some FOIA officers who don't really work with it are like, oh my goodness, 1 million records, but really that's not a big deal. Like, Microsoft Excel handles 1 million records, it's not a big deal. We just put it on a thumb drive. Their response was to print out every single record, like on paper like this, and ship 600 pounds of documents to McLean, Virginia at the cost of like $800 via FedEx. I'm like, you're clearly doing this because you don't want me to have the records. And just walking through, well, we can't export it to a system. Okay, well then I'll write a story saying that your agency spent $30 million in a system that doesn't work with anything else. Okay, then they hang them, okay, we'll get back to you, Jack. And then an hour later, do you want to come down with a thumb drive? We'll give it to you. Then I'm like, okay, that's all we needed to do. That's all we needed to do,
Yeah.
I just wanted to discuss a couple of insidious things we've seen in Georgia. Many of you know in some states there's these tuition tax credit legislation in which private individuals can divert state taxes into not-for-profit organizations that then use that money to pay private school tuition. It's happened in 7 or 8 states across the nation. It's growing. It comes out of the American Legislative Exchange Council. And it's another way of getting around the fact that most legislatures have killed the tuition voucher bill. In Georgia, a state senator offered an amendment to it after it had passed and been in operation for a couple of years, and said this is all about increasing transparency. And of course, what it really was to take every single record related to this behind a privacy wall and to declare that no one could have access to it and that criminal penalties would be brought against anyone in state government who released any information, so that all we know is one number, and that's how much money has been diverted from the state treasury, and it's $170 million at this point in Georgia. So that's one thing that I think, and I think somebody touched on that, bill by bill, act by act, you have to look at every single word to find those little, trigger mechanisms that take things private that previously were public. The other thing I want to say that was insidious has to do with, under the guise of offering greater transparency, there are state officials who will say, we are posting all of our data on the web, and you can get all this information. But what they're not giving you any longer is the relational database that's behind it. So that we used to get it at the Atlanta Journal-Constitution, a database of who would even want this except a newspaper, of all new corporations every month. New corporations, new LLPs, new LLCs. Why? Because you want to say, you want to do a trend story on nail salons booming in Southwest Georgia as opposed to auto repair shops in North. Who knows what you'd ever use it for? It's just routine. And the Secretary of State posted on an FTP site. We download it if we remembered to download it, and use it if we wanted to use it. The new Secretary of State comes in and says, that was a backroom deal with the HAC, we're no longer going to do that, we're going to be more transparent and put it up on a website, which is a drop-down menu, so that you can no longer do a search on State Senator Glenn Richardson and all of the companies that he's got a hand in. or, you know, any kind of searching you want to do through relational database, you can't use the word manipulate because they say, aha, you want to manipulate the news, but we know what that means, that you want to manipulate the data to pull out what you want. You can't do that anymore. And they say they're being more transparent.
Well, law enforcement is amazingly adept at hiding information behind, I mean, on the federal level, everything from Patriot Act and secrecy issues down to citing, you know, HIPAA or what, you know, runs the fire department is making. I mean, you know, which is just doesn't apply to the first responders at all. But it's an amazingly adept system now that's grown up. As FOIA has aged, so have the people who want to hide the information. They've gotten very skilled at it.
I also think, I agree, the sort of pretty-looking websites that are claiming to provide information, I mean, that's not meeting an obligation to provide specific information. And so you don't know what they've decided to put up and what they've decided not to, and I think that I find that very concerning every time I look at one. Because it looks like you're getting information, and that's always the most dangerous position to be in, I think.
It's,
you don't know what you're missing.
It's because of that there's this new subgroup. It's probably going to be a big group called hacker journalists. That's what they like to call themselves. I'm sort of one. I do a lot of programming as part of my job because I feel like it's no longer a niche. It's like I needed to actually get things done, and that you would have somebody, like a computer nerd programmer, come in and go, oh, interesting site. Let me look underneath the hood and try to scrape all that data. Which, again, that's sort of the practical matter of getting it done. But at the end of the day, that big website relational database that has the record layout, basically it's like the scaffolding of the database is what the record layout is, what these fields mean, who accessed it when. You know, you can get that sort of first level story, but that, you know, of who owns all the nail salons if you get that hacker journalist to get underneath all that data. But the bottom line is two things. A, it doesn't give you the complete picture by any means. And B, I'm sorry, but the taxpayers of Georgia paid for that information and they have a right to it, period. And, you know, I'm a firm believer, and I'm sure people in this room might disagree, that writing about records denials in and of itself is things that we should be doing more often. I had one FOIA officer came to me and she said, you know, well, are you going to, you're going to use your power, ink by the barrel, and liquor by the court to shame me into giving these records? I said, you're damn right I am. I don't care. Like, and she said, fine, I'm giving you these records because I'm so tired of you calling all the time. And she actually said, and this was a school district in Arizona, Amphitheater Public Schools, the superintendent said, I'm tired of the public thinking we have something to hide. We'll give you the data. And, you know, that's, I'm sorry to say, rare. That's a rare thing. But I was like, good for you. I almost should have given her balloons or something. But then again, that's doing her job. So, I don't know.
Other questions? Terry.
For Christine, yesterday we heard Pulitzer panelists, one of them was Eileen Sullivan from the AP, and was talking about the New York City Police Department's secret unit and the spying on the Muslim community. And you're involved with this litigation now with the civil rights movement. Part of this, you know, what's come out is kind of cold water, I think, on the American public of, yes, your government is keeping track of you, and for what purpose we still don't know. The case that you're working on, can you tell us what was the most surprising or disgusting or disheartening part about the whole thing when you started to really dig into this for your client? And also, I guess part two of this, what would you advise a client coming to you with something about this? What should we be doing up front before we actually have to come knock on your door?
Okay. As to the first thing, the most disheartening issue was, I'm really surprised. It took a long time. I guess there's two things that I find disheartening. One is how long it took to get here. I mean, we filed this case in November of 2010. And so almost 2 years ago, I was mentioning that one counsel on either side, we've had babies since then. Our kids are going to be in preschool by the time that this is decided. It's frustrating. I mean, you're writing a story and you don't have 2 years to wait to go through this litigation. And the number of motions for reconsideration that I've seen, my client asked the other day, how many times can they ask the judge to reconsider to decide that she's gotten it wrong? it's just not working for them, but it's costly to defend, and they know that it's a waiting game to them. So that's one concern that I have. The other issue is it took a long time for them to finally come out and say, we think that this is for a law enforcement purpose. And at what point the agency got comfortable with the fact that they were going to make this argument, I find it pretty disheartening to see that. And then in terms of what you can do, I think being very clear in your request so that if you have to litigate it, it's very clear where the records are, what they've done, what they haven't done, and what exactly you're looking for. And then the other thing that's been really successful in our case is reminding the court what your story is. Because the agencies really like to argue about abstractions. I mean, in our case, the FBI claimed a ton of exemptions, but really exclusion C2 was the big thing they wanted to say initially, and now it's going to be exemption 7D. They actually go through and argue in their motion or their briefs. They address them in order. So they're talking about exclusion 2, which no one really cares about. I mean, it's, in our case, no one cares about it. It's not the main issue. The main issue is, can you withhold confidential employment files? And they just want to bore the judge, basically, with sort of boilerplate law and say, oh, and defer to us. And just keep reminding the court that there's a story here, and the reason why the records are important, the public interest in seeing what's out there, I think is very important, and it really worked with our judge in this case.
And you know, and this story, if I may, we've had some local panels and discussions about this story about Ernest Withers, who was a photographer, who was very, very close, admitted to the inner circles of the civil rights movement as a photographer, hailed as a pioneer and a groundbreaking part of the effort to of the civil rights movement. At one point, a museum in Memphis was being created, and then you discover that, and I still don't know, and you may not be able to say whether he was coerced into being an informant or if he was voluntarily an informant for his own reasons. At least from what I've read, I can't yet tell.
We don't know either.
But anyway, this person was placed, and you know, and just take the worst case scenario, which we don't know yet. The nation's premier law enforcement agency, if you will, in the 1960s, may have coerced an American citizen into informing at the highest on people at the highest level of the civil rights movement for unspecified purposes, perhaps unrelated to really law enforcement concerns. I mean, that's the worst case scenario of this. And how many, 50 years later, we are still trying to get from a federal agency the history, not the current. I mean, Mr. Withers is gone. All the people he informed, or most of the people he informed on, are either gone or no longer in a position of power or authority in the way they were in the 1960s. The movement has moved on. And we still can't get that. And yet, I think the public often hears from the agencies that this is somehow an intrusion on the law enforcement process or an invasion of privacy of the Withers family. You know, and again, we don't do enough as an industry to write an editorial explaining why you need to know, readers, users, you know, why we're on your side. And along with a lot of other circumstances that you face, the government is actually now trying to say we're defending the public. They're the tribune for the public against these Visigoths of the press who would invade your privacy. And we're not doing enough, I think, as an FOI community to say, wait a minute, that's all wrong. Look back at this. Records are presumed public unless closed by specific exclusion. They're your records. We're not really doing enough. We're talking about what can we do to convince the public why they have an oar in that water.
There is another solution. There's another solution that I wanted to mention. That I'm Hank Libanoff. I'm out of Atlanta, Georgia, and did a lot of work on Ernest Withers and a book I wrote, and worked a lot on unsolved civil rights murders in the South. And have actually, in conjunction, took on an idea from Thomas Bland at the National Security Archive, who pointed out that twice in American history, Freedom of Information advocates have gone to Congress and said, we want you to declare that the Freedom of Information Act has failed in certain areas. One was the JFK assassination papers. The other was Japanese and Nazi war crimes papers. And we want you to declare that the Freedom of Information Act has failed, and therefore, we, Congress and the President, are passing legislation to authorize creation of an independent review board that is empowered to accumulate every single record on those topics across the broad range of federal agencies that would happen. And they did that in the JFK case. You know, it was somebody from the American Bar Association, a professor from American University, a history professor. It was a real mix of people who were astute and who really didn't have any axe to grind, didn't have any reason to protect the bureaucracy of the FBI or individuals. I mean, there were some ground rules. You couldn't just release everything, but they were charged with going through every single record and releasing everything that could. And then they went out of business. And then the same thing with the Japanese war crimes, slightly different. Their bureaucrats were actually making the decision, but they were overseen by a lay board. My proposal to several people in Congress and to Attorney General Holder was that we come before Congress with legislation to do this. As regards civil rights, the whole era of civil rights, I mean, it's all in the definitions. We were looking for civil rights murders, how about other crimes, a lot of beatings, whatever it would be. I think that would be a great thing for major organizations to take on. APME, National Press Foundation, Freedom Forum, and so forth, and to get behind that. And I'm happy to talk to anybody about it.
Hank, did Holder have a response or just take it under advisement?
Well, yes, he said we would be open to that. Keep in mind, he was in the AG's office when those two other laws passed. It was in 92 and 96, I think, in the Clinton administration. So, you know, as far as he's concerned, and frankly the FBI to some extent, this is a pain in the butt. For the number of people I have, and I'm sure that you have, sending them FOI requests over civil rights thing, and they can't find it. Sometimes, whether they're making a good faith effort, I don't know. I think they could be persuaded that it's a one and done. And I can tell you the only place that we found resistance. John Kerry introduced a bill as regards the Martin Luther King assassination. And one person spoke up and said, we're concerned about this, and it died. And that one person was Marty King III. And so the King family had some concerns about what might come out. But other than that, you know, I think Republicans would be behind this just as much as Democrats. No one's got any reason to want to protect old Klansmen on something like this.
Congress should put itself under FOIA too in that process, but that's a whole other.
That's another, yeah.
Got a question in the back?
Tangentially related to that, I don't know how it is in other states, but Connecticut has a formal Freedom of Information Commission with members, I don't even know who appoints them, governor or whatever, that has the power to fine public officials for not obeying the Freedom of Information Act. And it's a great resource for us because we can file, we make the request, we get denied or delayed, and we file a complaint with the Freedom of Information Commission, and they rule on it. And they'll even sue on our behalf. They'll fine, and then they're suing on our behalf right now on an important case regarding arrest warrants, access to arrest warrants, where we won. We won the case of the commission. They released it, but the state police sued to get that overturned. To not set the precedent that they have to really, and we actually lost in court. And this sort of actual state agency is appealing that to the Connecticut Supreme Court for us to fight for freedom of information. So it's like an independent government agency fighting against the other parts of the government. So it's an interesting model.
I have a general impression, by the way, that that's much more prevalent in the Northeast, and the further west you move, the less likely it seems to be adopted. I don't know if it's that less government movement, you know, the further west you get, but it seems like northeastern states are much more open to that idea. But you know, on the federal level, we have the Office of OGIS, Office of Government Information Services.
Yeah.
The very nice person, Miriam Nesbitt, and her report to Congress was finally, I think they had to threaten to throw half of the Obama administration in jail just to get the report from her office about how her office was doing up to the Hill. I mean, you know, so there is, you know, even the agency that's supposed to fight for information on a federal level like that ran into its own Freedom of Information blockade when they were afraid, I think, they would give away the store on non-compliance. So.
Yeah, in terms of just they mediate issues, so the agency has to be open to it in some way, because we initially did submit a request to them to mediate this, and they laughed at us.
Yeah.
I have a question against the wall.
I kind of have an off-topic question. Where I am down in Augusta, there doesn't seem to be anybody, including lawyers, for the city lawyers that I have to do my FOIAs through. No one seems to be really too familiar with the law at all. Is there resources that I can use down there that I can?
Is a home run for you?
We've got some, the National Freedom of Information Coalition would be a good place to go as well, particularly on state issues. I think,
Reporters Committee?
Reporters Committee. I think, unfortunately, you're right. One of the, again, one of the ways to not comply is to just not have a mechanism to comply. That's easy, and you get the, oh, we can't download it information, or we're not sure which person will do this or do that, particularly on a municipal level.
Are you familiar with the Reporters Committee for Freedom of the Press?
Yeah, I mean,
My best friend works there, so you guys
Yeah.
absolutely should do that.
There you go.
But they're great.
yeah, I mean, it just gets to the point where, I'm pretty sure that the lawyers know more than they're letting on to, you know what I mean?
Yeah.
So it's just, I mean, I'm wondering if there's something legally, that I can say, hey, you have to get going on this.
Well, a great mechanism is if your state press association has maybe not permanent counsel, but somebody on call to handle FOI requests. And if they don't, that might be a good place for a state press organization to start. I think the second thing, again, is this issue of, and this bothers all of us here at the center. We often don't do enough to just talk about why, to the public, why do you need to know? We just judged a First Amendment competition for the Northeast, for the New England Newspaper Press Association. And I don't think they've disclosed the winner, but I can tell you it was a combination of news stories about non-disclosure and editorials naming the names of people who won't disclose. A year ago, I was a judge in the Scripps Howard competition, and a small newspaper from North Carolina won. And what was delightful about their entries, they were doing investigative reporting by things like getting the documents and laying them out on the kitchen floor. I mean, this is real base level FOI work. But they wrote stories that said, well, we went into the police department to ask about, I think it was vacation people, and the sergeant said the captain wasn't there. And they take you through that narrative. Sergeant John Jones says Captain Bill Smith is at lunch, and we came back 3 hours, and Captain Bill Smith is still at lunch. And then we asked for his supervisor who was on vacation. And they name names and hold people accountable. And eventually they got the information. The police officers actually they were going to another county and pawning their government-issued weapons for money. It's very interesting. But they got it by just that old-fashioned work. And so sometimes I don't think it's litigation. I think it's just publicly holding people accountable and not being embarrassed about doing it.
And that's really interesting. That's the second time today second time this conference, and somebody's mentioned to me to, really involve the editorial team.
Yeah.
Because they do have that kind of public, people read that part of the paper, and they agree with it. So that's interesting. Thank you.
A question here.
Right, a question for Christine about beyond the specifics of the case, should eventually get the outcome fully in your favor. Are there precedents there that could be countrywide? Is that one of the fears of the FBI, or is everything sort of specific to this case's outcome?
They're particularly concerned, at least in their papers, that if they release the name of a confidential informant, or if they release information about a confidential informant, they're not going to be able to recruit confidential informants in the future. I mean, that's the underlying justification for withholding the documents to begin with. We don't see that. The judge has been pretty clear that this is a unique case. But I do think that one of the areas where we might be able to, where this could create good precedent for open records policies, is in terms of access to historical records. Not just law enforcement records, but I think last summer there was a case in DC where they opened up, Judge Lambert ruled that documents concerning the grand jury proceedings during the Nixon administration and Watergate were not, couldn't be sealed anymore. He unsealed the documents. And again, on this historical basis, none of the issues, the reasons that we keep grand jury proceedings secret just don't apply at this point. Anyone who is involved has spoken out publicly at this point.
Or written books.
Or written books,
Right.
or is deceased. I mean, just the overarching policy goals don't apply to those records anymore. And that came out just as we were briefing something in this case, and we cited that. And this could be seen as another case in line with that the judge referred to it the other day as ancient history. And she said it had been laid bare by the church committee. And this is just not what these exemptions were really there for. And so I think to the extent that this case can create precedent, I think that's where it could be useful, is access to historical records.
Yes.
Do you see any bright spots on the horizon, you know, either on the state, excuse me, or federal level that is going to give us any hope?
This to me, panel generally.
And panel, I guess.
No. But yes, I mean, yes, I mean, in some ways. I think, you know, the increased use of database reporting, the increasing skill of journalists as better trained, I hate to say this, younger reporters come online and have a facility for this data manipulation that older journalists have had to try to learn. And I think, again, you know, groups, you mentioned Tom Blanton's National Security Archive, and there's a host of non-governmental units that are cropping up that are really beginning to zero in on areas where, at least at the federal level, where, you know, there's been a move back to secrecy. It's produced a sort of third move, you know, back, a pushback against the pushback. State and local levels, I don't think are that well organized yet, although there's a Tennessee unit here that is doing a great job, I think, at looking over records. But we're still reacting to the reaction, I think, and so a lot of the trends, to me, are they're finding new ways to keep information secret, and those of us interested in open government haven't caught up with that, haven't reacted yet, because we're still waiting to find out all the new ways they're going to deny public records, like in that case.
Yeah, go ahead.
Well, I'd just like to ask Jack talk a little bit about campaign finance records, which I find to be the most frustrating thing going on.
Yeah. Talk about historical
Well,
records.
it's funny you mention that, because I was just going to say, I mean, maybe there's some lemonade to be made here from some very sour and unsavory looking lemons, and that is that maybe this is a chance where, I mean, I don't ever think FOIA should be the only reporting tool we use in a story, that maybe this is a chance now to really go back to the basics of like really tough, you know, pavement pounding, shoe leather reporting. And I'll give you an example with campaign. I mean, look, I love looking at databases and programming in C++ as much as the next guy. Maybe not, or whatever. And is this thing on? But I also love, you know, hitting the streets and like going looking at old boxes and doing some thing. And with the campaign finance reports, they by law have to show all of the, you know, sources of revenue, that is $200 or more aggregate, and all expenses, debts collected, at least at the federal level, particularly for presidential level. And one thing that I sort of kept hearing about was how the Romney campaign had been, you know, using some very, nothing necessarily wrong with it, but just very corporate ways of sort of getting people, you know, finding new donors and what have you. I poured over these data, I mean, very granular. I tried to look at every line item, I mean, you know, transaction 827J, whatever, and I couldn't find anything. So I spent 3 months of reporting, not exclusively, but sort of gathering string on and like talking to sources and, you know, getting people to talk, taking them out for I don't know how many beers, which if I can make a plug to editors, let your reporters spend money to take people out, you know, even if it's just for a coffee, because and I put this in a tip sheet as an aside, and we all know this, but to reiterate, sources hate nothing more than when you just call them up on deadline and they need something, like they need to have a relationship built with them. And we weaved together this story that Romney was employing this secret data mining using this company that nobody had ever heard of in Texas to basically trove through thousands of pieces of personal information about people, down to where they go to school, their kids' names, where they go to church, you know, which is, again, not necessarily shady because Fortune 500 companies do that, but he was using that sort of knowledge of corporate data gathering as he used at the time at Bain Capital and those companies on the presidential level. But if you look at, things that are available, not necessarily under FOIA, but campaign finance data, it wasn't there, period.
You may have already answered this question, but we do have a presidential campaign going, and somebody's going to win. If it's Romney, do you have any sense, any of you have any sense, based on statements by Romney or his supporters, as to where they would be on this FOIA issue?
I just know the campaign's very secretive. And Romney himself is very secretive. I couldn't imagine that that's going to change on the FOIA side. But at the same time, if I may say, the president is also, by his extent, very secretive. And it's sort of more disheartening, I'd say, from a very personal opinion, that this is the guy who comes to office and within the first 48 hours writes a memo to executive branch department heads saying, this is a new era in open government, which, by the way, I quote that thing liberally in every FOIA request I do. I was like, see Attorney General's memorandum to department agencies. And this is the same president who, when one of our editors put in, the same day of the Sunshine Week started, the administration went up to the Hill to ask for more exemptions to FOIA.
Yeah.
And we noted that in the story, as well as, I believe, the names of a couple of people who were on a background White House call, which, by the way, those names had already been out in the ether. It was, I think, either in a White House press release or what have you, but they were like, in background, you can't name these people. My boss went, whatever, and he named them in the story, and they got so mad we were shut out of 2 presidential press conferences because of it. And so I don't know if one's going to be better or worse than the other. I think, as my friend famously said to me once, what the executive wants, the executive gets, and that's a very dour way of looking at it, but I don't know. Maybe call me cynical, but hey, look at the job I don't know.
Well, the trend is, regardless of party, regardless of philosophy, toward more secrecy. The most transparent administration ever signed, first thing signed was that memo, I believe. First official act was to make the administration the most transparent ever. And we see even creation of a new category of secrecy being proposed. We have too many already, and they're proposing yet another one. I don't know that any campaign really wants to talk about freedom of information. It's another third rail. They all pledge, sure, we'll be open, and then the minute they get in, the trend, again, if you look back 30 or 40 years, it's just been more and more non-disclosure or attempts at non-disclosure. Maybe not so bold as, I'm trying to remember which Attorney General, maybe Bush 1, where the Attorney General literally wrote the memo that said to law enforcement agencies, I know that the FOI presumes records open until closed, but we will support you if you take the position of closed rather than open.
I think it was Ashcroft.
Yeah. Meanwhile, draping the statute of justice. What do you almost? It's almost incomprehensible to be faced with that kind of a memo, saying the law says this, but we'll support you if you take this position, that things are closed until they are forced open, and you can expend money to defend that position. So I think if there's a ray of hope, it's in this room.
Chris, did you want to comment, Christine?
Yeah, I have a quick comment on that. Just on the politics side of it, is one of the things, that's something that Judge Jackson did focus on when she was yelling about how this administration was arguing that these were law enforcement records, and she actually ordered that an assistant attorney general come to court the next time that we're in court in order to say whether the FBI would be willing to mediate this issue. She said, I really think this decision needs to be made at higher levels. I don't know if those people are involved yet or not, but I want someone in my courtroom. And that was, I thought, heartening.
There are actually, it's interesting, judges also are beginning to become allies in this in terms of documents within the court, because there's been a trend within court to file particularly settlements and arbitration agreements and then cloak them under some, it's a trade secret being protected or something like that. And I think the judiciary is beginning to push back on that. In part, they just don't want to have to keep track of everything that's supposed to be secret in the record. They don't have enough staff. They don't have enough, and they don't have an interest in that. I think they really do like justice in public as a whole on the judicial level. And so judges are becoming an ally in this fight because they're beginning to watch what they've always done traditionally in public suddenly be closed by motion of the parties, and they don't particularly like that. So I think there is a ray of hope with judges as well, who are, you know, if you think about who defends the public right, in effect, of the three branches and the fourth estate, it's the press and the free and independent judiciary. And those two groups need to step up. But there is a ray of hope, I think, on the judicial side as well.
Christine, let me ask you, are there other court cases around the country that you're aware of that are coming down the pike that might become newsworthy stories from the point of view of their impact on FOIA or their use of FOIA to open the box?
Absolutely. The one I saw the other day was on Reagan's domestic spy, and it was in the New York Times.
President Reagan, not Governor Reagan.
It was actually, Governor Reagan was receiving the information, so, from the FBI.
Mm-hmm.
And one of the stories that I think is just interesting is how much effort goes into fighting these cases, and how the plaintiff in that case has been battling I guess it's the FBI as well there, the FBI for years over this, and just the cost and how the government can really just dig its heels in and sort of wait you out because it is expensive to fight them.
Yeah.
So that's one of the stories that I think is out there that is interesting. I'm trying to think of other FOIA litigation. Off the top of my head, I'm
Okay.
just not thinking of it.
Gene, I want you to comment, if you can, on public attitudes towards this information disclosure. Have they changed over time? Have they been steady? Do public attitudes, and particularly towards the press, seem to warm up at times of crisis, such as 9/11, and then go back?
Well, I'd be hard-pressed to point to specific data, but I have a general impression that public support for FOIA, just as the idea of there are records, we need to see them, peaked. Maybe the late 90s, maybe. The rise of aggregation, the pushback from federal agencies having to deal with FOIA over a 20-year period, developing these exemptions, getting them through. We sort of, you know, public attitude is now, again, listening to government officials who are saying, we're protecting you from these invasive inquiries. And at the same time, of course, I think there is a generation growing up that's much less concerned about, you know, they post everything on Facebook, they tweet everywhere they're going. And I just don't know whether that sort of personal ease with information being available online still bothers me. First of all, I don't know why anybody would want to know I'm going to the airport, but secondly, I don't want people to know I'm going to the airport. You know, generally. My wife can know, but after that I get a little worried. So I don't know if if that ease is going to just show up at some point back in our camp where they say, well, of course, why not? Who cares? You know, it's just data about me that I put out there. Birth date, and friends, and likes, and families, and dislikes. But so I think we have these sort of countervailing trends that are, you know. But I think we're definitely in a down cycle in just support for what we would call traditional FOI kinds of initiatives. Last question. Let me ask you to help me thank the panel for an excellent presentation. We will all be around, and I want to thank Terry again for putting this on.